Okay, let's pick this up again. Just a second. I'll try this again. Okay, so in the King's Bench, there may also, and frequently do, proceed in certain causes, particularly in actions of ejectment or trespass, by original writ, with attachment and taking returnable, not to the the Court of Common Pleas, to the Court of Common Pleas, but to the King's Bench, being removable into any part of England and at the pleasure and discretion of the Crown. So it's going to go. This one goes to the King's Bench. So as things move ahead in the civil court, they're also in the King's Bench involved in separate action, two cases at one time. And it again starts with the original writ under the Great Seal. That's my opinion. Anytime they say an original writ, I'm not sure, but now this may be an original writ, but it's not under the seal of the Court of Common Pleas. It's under the Court of Law, the Court of Record. So this is what's actually happening in the Court of Record at the same time as what they're trying to do in civil law. Hope it makes sense when we all get to the end. But the more usual method of proceeding therein is without any original. Again, usually without any original, but by a peculiar species of process entitled a Bill of Middlesex, and therefore so entitled because the court now sits in that county. For if it sat in the Kent, it would be called a Bill of Kent. Check record of case, see where the bill is from. Does every state have a county of Middlesex? I don't know. They're going to say that's where the King's Bench sits, and so that's where this bill can issue from. Now, it won't be called a Bill of Middlesex. It'll be called something else. For those the justices of this court have, this is the King's Bench, by its fundamental constitution, power to determine all offenses and trespasses by the common law and customs of the realm, it needed no original writ from the Crown to give it cognizance for any misdemeanor in the county where it resides. Yet as by this court coming into any county, it immediately superseded the ordinary administration of justice by general commission of ire, oyer, terminer, and process of its own became necessary within the county where it sat to bring in such persons that were accused of committing any forcible injury. So wherever the King's Bench is, it supersedes the ordinary is ecclesiastical administration of justice. So this Bill of Middlesex is a kind of taking, directed at the sheriff of that county and commanding him to take the defendant, have him before our Lord the King at Westminster on the day prefixed to answer to the plaintiff of the plea of trespass. So this is to answer for a plea of trespass. How do you plead? Guilty or not guilty? That's for the trespass. For this accusation of trespass, it is that gives the court King's Bench jurisdiction over all civil causes. And as was formerly observed, since once the defendant is taken into custody of the marshal or prison keeper of this court, may here be prosecuted for any other species of injury. So they're looking for a reason to get you into court. They're going to say you did a trespass. How do you plead to the trespass? Guilty or not guilty? Yet in order to file in this jurisdiction, it is not necessary that the defendant be actually in the marshal's prisoner, for as soon as he appears or puts in bail to the process, he is deemed to be he is deemed by so doing to be in such custody of the marshal and will give the court jurisdiction to proceed. If you appear or put in bail, you have consented to jurisdiction with the King's Bench. And upon these accounts, in the bill or process, a complaint of trespass is always suggested. Whatever else may be the real cause of action, this Bill of Middlesex must be served on the defendant by the sheriff if he finds him in the county. But if he returns was not found, then there issues out in hiding to the sheriff of another county, which is similar to the taking in the common pleas, and recites the Bill of Middlesex, and proceeds thereon, and it is testified that the defendant lurks, wanders. Okay, so again, It recites the Bill of Middlesex from the other county, because this is going to another county now, and the proceedings thereon, says what's happened, and that it is testified to. Somebody's done it as a witness. Right? That's what should be on the piece of paper they're charging you with. But as in the common pleas, testified to take may be sued out only upon only a supposed and not actual proceeding taking. Go figure. So on the King's Bench, a Hyde himself is usually sued out upon only a supposed and not actual Bill of Middlesex. They didn't even do a Bill of Middlesex. There is no bill. So that, in fact, Hyde himself may be called the first process in the court of the King's Bench, and is the same as this other taking in the common pleas. So if we were to write these down one beside each other, we could see how, in fact, that's probably what I have to do for myself. These are the words used in common law for each thing. It's the same as this used in civil law. Okay? Because there's three courts moving at the same time on the same case. Yet, as in common pleas, if the defendant lives in the county wherein the action is laid, a common taking suffices. So the King's Bench likewise. If he lives in Middlesex, the process is still by Bill of Middlesex only. So that's what they're doing in the King's Bench. In the Exchequer, the third court, the first process is by writ of quo or minus. So there's another writ, which in order to give the court jurisdiction over pleas between party and party, which is in which writ the plaintiff is alleged to be the king's farmer. So this time he's saying he's your farmer or your debtor, and that the defendant has done him injury or complained by which he is less able to pay the king's rent or debt. And upon this, the defendant may be arrested upon a taking from the common pleas. You know, the plaintiff's admitting he's just a farmer. He's a tenant working for the king. And saying that you, because you've not said you're the king, are keeping him from the king's, able to pay the king's bill. Apparently. Thus differently do the three courts set out at first in commencement of a suit, for which the reason is obvious, since by this means the two courts, the King's Bench and the Exchequer, entitle themselves to hold plea in subject causes, which by original Constitution of Westminster were only empowered, which by original Constitution of Westminster Hall they were not empowered to do so. Afterwards, when the cause is once drawn into the respective courts, the method of pursuing it is pretty much the same in all of them. So afterwards, when the cause is once drawn into the respective courts, the method of pursuing is pretty much the same in all of them. Sounds to me like you can go to any one of these to make this thing go away. If you go to all three, because there's three court cases going, the attorney's going to have a bad day. If the sheriff has found the defendant upon any of the former writs, he is agently obliged to take him in custody. Right? So it didn't matter of the writs that have been talked about for either equity, common law, or chancery, or common pleas, whatever it is. He's supposed to take him into custody in order to produce him to court upon the return, however small and minute the cause of action might be. Because remember, all the way back in the civil case, if it's not under the Great Seal on an original writ, it's worth less than 40 shillings. I'm going to say that's the same as if it ain't more than $20, you don't get a jury trial. Therefore, the case must be worth $20 or less. I don't care what the numbers are on the paper. On the front, that's what they're going to be agreeing to on the back. For not having obeyed the original summons, he had shown a contempt of court, no longer to be trusted at large. But when the summons fell into disuse and the taking became the fact first process, it was thought hard to imprison a man for contempt, which was only supposed. Therefore, in common cases, by gradual indulgence of the court, at length authorized by, the sheriff or his officer can now only personally serve the defendant with a copy of the writ or process, and with notice in writing to appear by his attorney in court to defend the action, which in effect reduces it to a mere summons. So all they can give you is a summons. And so the sheriff in his office can not only personally serve the defendant with a copy of the writ or process, and with notice in writing to appear by his attorney in court to defend the action. So you should take that to the public prosecutor, to the king's attorney general. Hey, they brought this to me. The king can never be legally liable, as already said before, so if there's something wrong, one of his ministers must have made a mistake. So really, whenever you get a summons, take it to the prosecuting attorney. And if the defendant thinks proper to appear upon this notice, his appearance is recorded, and he puts in sureties for his future attendance and obedience, which sureties are called common bail, being the same two imaginary persons that are pledges the plaintiff's prosecution, John Doe and Richard Doe. So again, everything is a John Doe and a Richard right now. Or if the defendant does not appear upon return of the writ, or within 4 days, or in some cases 8 days after, the plaintiff may enter appearance for him as if he had really appeared, and may file common bail in the defendant's name, and proceed thereupon if the defendant had done it himself. If you don't show, they put the bail up. But if the plaintiff will make affidavit or assert upon oath that the cause of action amount to £10 or upwards, then in order to arrest the defendant and make him put in substantial sureties for the appearance, called special bail, is required by statute, that the true cause of action should be expressed in the body of the writ or process. So first of all, did he make such an affidavit? And then because he's going to swear it's worth more than 10 pounds, whatever that means, and he has to put the true cause on the paperwork. This statute, with any such intention of the makers, had like to have ousted the king's bench from all jurisdiction over civil matters without force. As the Bill of Middlesex was framed only for actions of trespass, a defendant could not be arrested and held to bail thereupon for breaches of civil contracts. But to remedy this inconvenience, the officers of the king's bench devised a method by adding what is called a clause "and also" to the usual complaint of trespass. The Bill of Middlesex, which is a complaint for trespass, commanding the defendant to be brought to answer the plaintiff of a plea of trespass, and also to a bill of debt, the complainant of trespass giving cognizance of the court, and that the debt authorized the arrest. So there they added the debt to the common law for trespass. And up earlier, at first they couldn't do that. They just keep changing the system. Now they're going to change it to our benefit. In return for which, Lord Chief Just North, a few years afterwards, in order to save the suitors of his court the trouble and expense of suing out special originals, directed that in common pleas, besides the usual complaint of breaking the plaintiff's close, messing with his soil, a clause "and also" might be added to the writ of the taking containing the true cause of action, as that the said Charles, the defendant, may answer to the plaintiff a plea of trespassing in breaking his own clothes, and also may answer him according to the customs of the court in certain plea of trespass upon promises of the value of £20, etc. So, okay. So it has to say what the value of the case is. The sum sworn by the plaintiff is marked upon the back of the writ, and the sheriff or other officer, the bailiff, is then obliged to arrest and take in custody the body of the defendant, and having done so, return the writ with taking the body endorsed thereon. If they look at you, they better, if they took you, they better, there better be on the back of the bill the amount that you owe, or the writ, or whatever it is we're talking about here. But they're saying that on the back this information's been put on. An arrest must be by corporeal seizing or touching the defendant's body, after which the bailiff may justly justify breaking open the house in which he is in, in which he is to take him. Otherwise he has no such power, but must watch his opportunity to arrest him. For every man's house is looked upon by law to be his castle of defense and asylum, wherein he should suffer no violence. Which principle is carried so far in the civil law that for the most part no such, not so much as common citation or summons, much less an arrest, can be executed upon a man within his own walls. So if you've been arrested in your house, it's been unlawful. Go complain to the frickin' prosecutor. Peers of the realm, members of parliament, and corporations are privileged from arrest. We should be a peer of the realm, and of course from outlawries, and against them the process to enforce an appearance must be by summons and distress infinite instead of by taking. So they have to send you a summons if you're a peer. Also, clerks, attorneys, and other persons attending the courts of justice, for attorneys being officers of the court are always supposed to be there attending, are not liable to be arrested by ordinary process of the court, but must be sued by bill, called usually a bill of privilege, and being personally present in court, as being personally present in court. Okay, must be sued by bill as being personally present in court. I have to think about that. Clergy performing divine services and not merely staying in the church with a fraudulent design are for the time privileged from arrest, as likewise members of convocation actually attending thereupon. Suitors, witnesses, and other persons necessarily attending any court of record upon business are not to be arrested during their actual attendance, which includes their necessary coming and returning. So they can't sit there in the frickin' room and arrest you, and no arrest can be made in the king's presence, nor within verge of his royal palace, nor any place where the king's justice is actually sitting. The king has, moreover, a special prerogative which his deed very seldom extends, that he may, by his writ of protection, privilege a defendant from all personal and many real suits for 1 year at a time, and no longer, in respect of his being engaged in his service out of the realm. So it looks to me like if you say you're the king, you can get somebody out for a year at a time. Don't know what that means yet, but there's something for somebody to think about. And the king also by common law might take his creditor into his protection, so that no one might sue or arrest him till the king's debt were paid. Notwithstanding such protection, another creditor may proceed to judgment against him, with a stay of execution till the king's debt be paid, unless such creditor will undertake for the king's debt, and then he shall have execution for both. And lastly, by some statute, no arrest can be made, nor process served on a Sunday, except for treason, felony, and breach of peace. When the defendant is regularly arrested, he must either go to prison for safekeeping or put in special bail to the sheriff. That's under the Bill of Middlesex, for the intent of the arrest being only to compel an appearance in the court at the return of the writ. The purpose is equally answered when the sheriff detains a person or he takes sufficient security for his appearance, called bail, because the defendant is bailed or delivered to his sureties upon their giving security for his appearance and supposed to continue in their friendly custody and instead of going to jail. So if somebody goes into you under their recognizance, I guess. The method of putting in bail to the sheriff is by entering into a bond or obligation. If one or more sureties, not fictitious persons as in former cases of common bail, but real substantial responsible bondsmen, to ensure the defendant's appearance at the return of the writ, which obligation is called bail bond. So with one or more sureties, so if a real man walks in and says he'll be the bail, then the guy should be released. That would be the bail. You don't have to pay any money to a bondsman. Somebody just needs to go and say that they're a living man and be the bail. The sheriff, if he pleases, may let the defendant go without any sureties. but that is of his own peril, for after once taking him, the sheriff is bound to keep him safely so as for coming into court. Otherwise, an action would lie against him for an escape. But on the other hand, he is obliged by these statutes, taken, if to be tendered, a sufficient bail bond, and the sheriff shall take bail for no other sum than is sworn by the plaintiff and endorsed on the back of the writ. So what's on the back of the writ? That's what the bail is. Upon the return of the writ, or within 4 days, the defendant must appear according to the exigency of the writ. This appearance is effected by putting in and justifying bail to the action, which is commonly called putting in bail above. This is to be done, and the bail that were taken by the sheriff below are responsible persons. The plaintiff may take an assignment from the sheriff of the bail bond and bring an action thereupon against the sheriff's bail. If this is not done, and the bail that were taken from the sheriff below are responsible persons, the plaintiff may take an assignment from the sheriff of the bail bond. And bring an action thereupon against the sheriff's bail. But if the bail so accepted by the sheriff be insolvent persons, the plaintiff may proceed against the sheriff himself by calling upon him first to... Okay, so if you go in there as a living man, well, then the sheriff's going to give the guy the $40, because that's what you said you were suing him for, $40, whatever the number was. But if the bail so accepted by the sheriff be insolvent person, the plaintiff may... So now if you go in there as a fiction, return the writ, and afterwards to bring the body of the defendant, and if the sheriff does not, then the cause sufficient bail to be put in above, he will himself be responsible to the plaintiff. The bail above or bail to the action must be put in either in open court or before one of the judges thereof, or else in the country before a commissioner appointed for the purpose by virtue of the statute, which must be transmitted to the court. These bail, who must be at least 2 in number, must enter into recognizance into the court before a judge or commissioner, whereby they do jointly and severally undertake that if the defendant be condemned in an action, he shall pay the cost in condemnation or render himself a prisoner, or that they will pay it for him, which recognizance is transmitted to the court in a slip of parchment entitled a bail piece. So you can go in and be somebody's bail if they're being held for bail right now, and again, you go in recognizance in a court or before a judge or commissioner, whereby they do jointly severally undertake that if the defendant be condemned of an action, he shall pay the cost in condemnation or render himself a prisoner. See what condemnation is. And if required, the bail must justify themselves in court or before the commissioner of the county by swearing themselves housekeepers, and each of them to be worth double the sum for which they are bail, after payment of all their debts. The answer is in some measure to stipulation of the Roman laws, which is mutually given by each litigant party to the other by the plaintiff that he will prosecute a suit and pay the cost if he loses. This answers in some measures the stipulation of the Roman law, which is mutually given by each litigant party to the other. So we gave them bail, so now the plaintiff must be giving us something by the plaintiff that he will prosecute a suit and pay the cost if he loses his cause. In like manner, our law still requires nominal pledges of prosecution from the plaintiff by the defendant that he shall continue in court and abide the sentence of the judge, much like our special bail, but with the difference that the sureties were there absolutely bound to see the cost and condemnation paid at all events, whereas our special bail may be discharged by surrendering the defendant into custody within the time allowed by law, for which purpose they are at all times entitled to a warrant to apprehend him. Special bail is required, as of course, only upon actions of debt or actions of case or trover or special money due, where the plaintiff can swear that the cause of the action amounts to £10. So if they want you to have special bail, they have to swear that the amount's over £10. But in actions where damages are precarious, being to be assessed at pleasure by the jury, as in actions of words, ejectment, or trespass, it is very seldom possible for the plaintiff to swear the amount of the cause of his action, and therefore no special bail is taken thereon unless the judge ordered of particular directions of the court and some peculiar species of injuries, as in case of mayhem, atrocities, battery, so the real bad stuff, and upon such special circumstances as make it absolutely necessary that the defendant should be kept within the reach of justice. Okay, so special bail. Where was special bail? Where were they hitting us with that? Oh, was it up here? Whoop. Where the defendant is regularly arrested, he must go to prison for safekeeping or put in special bail to the sheriff. Special bail, King's, I don't know, special bail, King's Bench, Bill of Middlesex. Okay, those go together. When you're in the King's Bench, you put in special bail because of a Bill of Middlesex. So that's why I need to do a flow chart so that I can keep up with what all that shit means. Anyways, special bail can only be used in certain circumstances. When the guy's going to say, it better be, he better swear that the action is more than £10, $10, $20, whatever it is. And because it's very seldom possible for a plaintiff to swear the amount of the cause of action, therefore no special bail is taken thereon. In all civil actions against heirs, executors, and administrators for debts of the deceased, special bail is not demandable, for the action is not so properly against them in person as against the effects of the deceased in their possession. But the special bail is required even of them in actions of wasting of the goods of the deceased, that wrong being of their own committing. Thus much for process, which is only meant to bring the defendant into court in order to contest the suit and abide the determination of the law. When he appears either in person or as a prisoner or out upon bail, then follow the pleadings between the parties, which we shall consider at large in the next chapter. Okay, so this was Blackstone's on the process. That's the process. And we're going to go next to the pleadings. That'll be part 4. Okay, talk to you all later.